Chapter 16, Presentment, Notice of Dishonor and Protest. Section 149. Meaning of terms. By presentment is meant the production of a bill of exchange to the drawee for his acceptance, or to the drawee or acceptor for payment, or the production of a promissory note to the party liable for payment of the same. By protest is meant a formal statement in writing made by a notary under his seal of office, at the request of the holder of a bill or note, in which it is declared that the same was on a certain day presented for payment, or acceptance, as the case may be, and that such payment, or acceptance, was refused, and stating the reasons, if any, given for such a refusal, whereupon the notary protests against all parties to such instrument, and declares that they will be held responsible for all loss or damage arising from its dishonor. By notice of dishonor is meant a notification to the parties on an instrument whom it is desired to hold liable on such instrument. If such notice were given by a notary, it would be called a protest. When a negotiable bill or note is dishonored by non-acceptance on presentment for acceptance, or by non-payment at its maturity, it is the duty of the holder to give immediate notice of such dishonor to the drawer, if it be a bill, and to the endorser, whether it be a bill or note. Section 150. In general, we shall now consider the matter of presentment and notice of dishonor. What was the contract of the drawer and the endorser? He says, I will pay this instrument if you present the instrument to the parties to whom it should be presented and by whom it should be accepted, and if they do not pay it or accept it, I will pay it, but my contract is that it must be presented to them first. Now, if it is not shown that the instrument was presented for acceptance or payment, then he will not be liable on it. These things may be waived by contract, but when not waived they must be established. Presentment for acceptance or presentment for payment must be made in order to hold certain parties on the instrument, because that is the contract they enter into. As to presentment for payment, the contract of the drawer is that he will pay the instrument providing the acceptor does not, and he is duly notified of that fact. The endorser makes the same contract with his subsequent endorsers. He says, you notify me of the fact that the drawee does not pay that instrument and I will pay it. Therefore, if we are going to hold the endorsers, we must perform our part of the contract. The instrument may be dishonored for failure to accept also. Section 151. Presentment for acceptance, when essential. In a previous chapter we have discussed acceptance. We shall now consider presentment for acceptance. In certain cases presentment for acceptance is not essential, and in others it is. In those jurisdictions where days of grace are recognized, a bill payable at sight must be presented for acceptance. A bill payable after sight, say 5 days after sight, should be presented for acceptance and then after that for payment. So many days after demand requires presentment for acceptance. The negotiable instruments law provides, presentment for acceptance must be made, 1. Where the bill is payable after sight, or in any other case, where presentment for acceptance is necessary in order to fix the maturity of the instrument, or 2. Where the bill expressly stipulates that it shall be presented for acceptance, or 3. Where the bill is drawn payable elsewhere than at the residence or place of business of the drawee. In no other case is presentment for acceptance necessary in order to render any party to the bill liable. Section 152. Presentment for acceptance. Benefit. What is the benefit of presentment for acceptance? A draws on B in favor of C. Well, you can see it is an advantage to if C notifies him that B refuses to accept that instrument. A knows he must take care of himself in regard to B, and it helps C because it makes him know where he must look for his money, that is, to A. Section 153. Presentment for acceptance. Time. The time for presentment is in a reasonable time. The hour of the day for presentment, if you are presenting it to a businessman, is at his office during his office hours. You apply your common sense as to the time of day for the presentment. The negotiable instruments law has the following provisions governing this subject, except as herein otherwise provided. The holder of a bill which is required by the next preceding section to be presented for acceptance must either present it for acceptance or negotiate it within a reasonable time. If he failed to do so, the drawer and all endorsers are discharged. A bill may be presented for acceptance on any day on which negotiable instruments may be presented for payment under the provisions of sections 132 and 145 of this Act. When Saturday is not otherwise a holiday, presentment for acceptance may be made before 12 o'clock, noon, on that day, where the holder of a bill drawn payable elsewhere than at the place of business or the residence of the drawee has not time with the exercise of reasonable diligence to present the bill for acceptance before presenting it for payment on the day that it falls due. The delay caused by presenting the bill for acceptance before presenting it for payment is excused and does not discharge the drawers and endorsers. Section 154. When instrument dishonored by non-acceptance. As to when an instrument is dishonored by non-acceptance, the negotiable instruments law provides, a bill is dishonored by non-acceptance, 1. When it is duly presented for acceptance, and such an acceptance as is prescribed by this Act is refused or cannot be obtained. 2. When presentment for acceptance is excused and the bill is not accepted. Where a bill is duly presented for acceptance and is not accepted within the prescribed time, the person presenting it must treat the bill as dishonored by non-acceptance, or he loses the right of recourse against the drawer and endorsers. When a bill is dishonored by non-acceptance, an immediate right of recourse against the drawers and endorsers accrues to the holder, and no presentment for payment is necessary. It should be here noted that the negotiable instruments law provides, where the instrument is made payable at a bank it is equivalent to an order to the bank to pay the same for the account of the principal debtor thereon. Section 155. Presentment for payment in general. The engagement entered into by the acceptor of a bill and the maker of a note is, that it shall be paid at its maturity, that is, on the day that it falls due, and at the place specified for payment, if any place be designated, upon its presentment. This engagement is absolute, but that of the drawer of a bill and the endorser of a bill or note is conditional and contingent upon the true presentment at maturity, and notice in case it is not paid. It is not necessary that a presentment for payment should be personal. It is sufficient if made at the place specified in the instrument, or personally if the maker or acceptor waives his right of having it made at the place stipulated in the contract, or, if no place is specified in the instrument, then if made at the place of business or residence of the maker or acceptor. The drawer of a bill and any endorser may insert thereon the name of person to whom the holder may resort in case of need, that is to say, in case the bill is dishonored by non-acceptance or non-payment. Such person is called the referee in case of need. It is in the option of the holder to resort to the referee in case of need or not, as he may see fit. Section 156. Presentment for payment, when essential. As to when presentment for payment is essential, the law generally is as set out in the Negotiable Instruments Law, which provides as follows. Presentment for payment is not necessary in order to charge the person primarily liable on the instrument, but if the instrument is, by its terms, payable at a special place, and he is able and willing to pay it there at maturity and has funds there available for that purpose, such ability and willingness are equivalent to a tender of payment upon his part. Presentment for payment is necessary in order to charge the drawer and endorsers. Presentment for payment is not required in order to charge the drawer where he has no right to expect or require that the drawee or acceptor will pay the instrument. And presentment for payment is not required in order to charge an endorser where the instrument was made or accepted for his accommodation, and he has no reason to expect that the instrument will be paid if presented. Section 157. Presentment for payment, when dispensed with. Presentment for payment may be dispensed with as set out by the terms of the Negotiable Instruments Law, which provides, presentment for payment is dispensed with, 1. Where after the exercise of reasonable diligence presentment as required by this Act cannot be made. 2. Where the drawee is a fictitious person. 3. By waiver of presentment express or implied. Section 158. Presentment for payment. What's sufficient? As to what constitutes a sufficient presentment, the Negotiable Instruments Law provides, presentment for payment, to be sufficient, must be made, 1. By the holder, or by some person authorized to receive payment on his behalf, 2. At a reasonable hour on a business day, 3. At a proper place as herein defined, and, 4. To the person primarily liable on the instrument, or if he is absent or inaccessible, to any person found at the place where the presentment is made. The instrument must be exhibited to the person from whom payment is demanded, and when it is paid must be delivered to the party paying it. This is the law generally. Section 159. Presentment for payment. Date. In ascertaining the proper date for presentment, the day of the date is excluded, so where the paper is payable 1 year from date it will mature on the first anniversary of that date. The negotiable instruments law provides, where the instrument is payable at a fixed period after date, after sight, or after the happening of a specified event, the time of payment is determined by excluding the day from which the time is to begin to run, and by including the date of payment. Thus in an instrument payable so many days after sight, or after date, the day of sight or date is excluded and the day of payment included in the computation. Another provision relating to the date of presentment is the following. Where the instrument is not payable on demand, presentment must be made on the day it falls due. Where it is payable on demand, presentment must be made within a reasonable time after its issue, except that in the case of a bill of exchange, presentment for payment will be sufficient if made within a reasonable time after the last negotiation thereof. Presentment for payment cannot be made on a Sunday or legal holiday, and if the note matures on a holiday or Sunday, since the maker cannot be compelled to pay sooner than he had promised, the note or bill will have to be presented on the next business day. The negotiable instruments law provides, every negotiable instrument is payable at the time fixed therein without grace. When the day of maturity falls upon Sunday, or a holiday, the instrument is payable on the next succeeding business day. Instruments falling due on Saturday are to be presented for payment on the next succeeding business day, except that instruments payable on demand may, at the option of their holder, be presented for payment before 12 o'clock noon on Saturday when that entire day is not a holiday. By usage, the banks in some states give notice to the promisor a few days before maturity of the fact that the paper will be due on a named day, and it has been held that this preliminary notice will take the place of a formal presentment on the day of maturity. Section 160. Presentment for payment. When delay excused. As to when delay in making presentment for payment is excused, the following provision in the negotiable instruments law sets out the law in general. Delay in making presentment for payment is excused when the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct or negligence. When the cause of delay ceases to operate, presentment must be made with reasonable diligence. Section 161. Presentment for payment place. The following provisions are found in the negotiable instruments law, and represent the law generally, as to the place of presentment for payment. Presentment for payment is made at the proper place. 1. Where a place of payment is specified in the instrument and it is there presented. 2. Where no place of payment is specified, but the address of the person to make payment is given in the instrument and it is there presented. 3. Where no place of payment is specified and no address is given and the instrument is presented at the usual place of business or residence of the person to make payment. 4. In any other case, if presented to the person to make payment wherever he can be found, or if presented at his last known place of business or residence. Where the instrument is payable at a bank, presentment for payment must be made during banking hours, unless the person to make payment has no funds that to meet it at any time during the day, in which case presentment at any hour before the bank is closed on that day is sufficient. Section 162. Presentment for payment to whom. When a bill is payable generally or at a particular place, no presentment is necessary to charge the acceptor, as it is his duty to be on hand to pay or seek out his creditor to pay him. Where the person primarily liable on the instrument is dead, and no place of payment is specified, presentment for payment must be made to his personal representative if such there be, and if with the exercise of reasonable diligence, he can be found. Where there are several persons not partners, primarily liable on the instrument, and no place of payment is specified, presentment must be made to them all. Where the persons primarily liable on the instrument are liable as partners, and no place of payment is specified, presentment for payment may be made to any one of them, even though there has been a dissolution of the firm. There is no doubt that a clerk found at the counting room of the acceptor or promisor is a competent party for presentment for payment to be made to. without showing any special authority given him. But where the protest stated the mere fact of presentment at the office of the maker, it will be considered insufficient, as not showing that the paper was presented to the party authorized to pay or refuse payment. A demand upon the servant of the owner who used to pay money for him was held sufficient in England. $163. Presentment for payment. Effect of failure to present. The maker and acceptor are bound, although the bill or note be not presented on the day it falls due, but the drawer and endorsers are discharged if such presentment be not made, unless some sufficient cause excuses the holder for failure to perform that duty. Section 164. When instruments are dishonored by non-payment. The instrument is dishonored by non-payment when 1. It is duly presented for payment and payment is refused or cannot be obtained, or 2. Presentment is excused, and the bill is overdue and unpaid. Section 165. Notice of dishonor. In general, notice of dishonor is bringing either verbally or by writing, to the knowledge of the drawer or the endorser of an instrument, the fact that a specified negotiable instrument, upon proper proceedings taken, has not been accepted, or has not been paid, and that the party notified is expected to pay it. The notice may be in writing or merely oral, and may be given in any terms which sufficiently identify the instrument, and indicate that it has been dishonored by non-acceptance or non-payment. It may in all cases be given by delivering it personally or through the mails. Section 166. Contents of notice. In order that the notice may be complete, it should contain 1. A sufficient description of the bill or note, 2. A statement that it had been presented for acceptance or payment, and had been dishonored, 3. A statement that the paper had been protested, and 4. An announcement of the intention of the holder to look to the party addressed for payment. A statement of non-payment is not sufficient without a statement that presentment and demand had been made, but if the word dishonored is used it is held to be sufficient without further statement of presentment and demand. Notice is sufficient if the necessary facts can reasonably be inferred from the terms of the notice. A written notice need not be signed, and an insufficient written notice may be supplemented and validated by verbal communication. A misdescription of the instrument does not vitiate the notice unless the party to whom the notice is given is in fact misled thereby. No misdescription of the amount, or of the date, or of the names of the parties, or of the time the paper falls due, or other defect vitiates the notice of dishonor, unless it misleads the party to whom sent. Section 167. By whom given and when to be given. The proper party to give the notice is the holder or his authorized agent, or an endorser who is at the time of giving it liable on the bill and who has a right of recourse against the party to whom notice is given. That is, the notice must be given by a party to the paper or his agent, and a total stranger cannot give proper notice of dishonor. The notary may give the notice as agent for the holder, and so may any bank holding the paper for collection. The notice may be given by or on behalf of the holder, or by or on behalf of any party to the instrument who might be compelled to pay it to the holder, and who upon taking it up, would have a right to reimbursement from the party to whom notice is given. Notice of dishonor may be given by an agent either in his own name or in the name of any party entitled to give notice, whether that party be his principal or not. Where the instrument has been dishonored in the hands of an agent, he may either himself give notice to the parties liable thereon, or he may give notice to his principal. If he gives notice to his principal, he must do so within the same time as if he were the holder, and the principal, upon the receipt of such notice, has himself the same time for giving notice as if the agent had been an independent holder. If the holder die before the time for presentment for payment, it must be made by his personal representative. If there be no personal representative at the time, presentment and demand within a reasonable time after his appointment will be sufficient to charge subsequent parties, although presentment and demand were not made at maturity. Section 168. Notice of dishonor. To whom given. As to whom notice of dishonor should be given, the Negotiable Instruments Law provides, when a negotiable instrument has been dishonored by non-acceptance or non-payment, notice of dishonor must be given to the drawer and to each endorser, and any drawer or endorser to whom such notice is not given is discharged, and notice of dishonor may be given either to the party him himself or to his agent on that behalf. The proper party or parties to be given notice are the drawer, endorser or endorsers, or their authorized agent or other person entitled to receive notice for them. That is, the notice must be given to all persons secondarily liable whom the holder wishes to charge. And notice should be given to endorsers who have endorsed for the purpose of collection, and endorsers of overdue paper. Where there are two or more joint drawers or endorsers who are not partners, notice of dishonor must be given to them all in order to bind either. When the note is executed by several joint promisors who are not partners, but liable only as joint and several promisors, it has been held that presentment should be made to each, in order to fix the liability of an endorser. And as provided by the Negotiable Instruments Law, notice to joint parties who are not partners must be given to each of them, unless one of them has authority to receive such notice for the others. Where the parties to be notified are partners, notice to any one partner is notice to the firm, even though there has been a dissolution. Where a party has been adjudged a bankrupt or an insolvent, or has made an assignment for the benefit of creditors, notice may be given either to the party himself or to his trustee or as signee. Notice left with a clerk or person in charge, at the party's place of business, in his absence, or at his place of business, without proof as to the person with whom it was left, is sufficient, and proof that such person was not the party's agent has been held irrelevant. Notice being left at the right place. Hence, leaving it with his private secretary at his public office is sufficient. If service be sought on the party at his dwelling, it is sufficient to leave notice with his wife, or with any other person on his premises. When any party is dead, and his death is known to the party giving notice, the notice must be given to a personal representative, if there be one, and if with reasonable diligence he can be found. If there be no personal representative, notice may be sent to the last residence or last place of business of the deceased. Section 169. Notice of dishonor. Time. As to the time in which notice must be given, the Negotiable Instruments Law provides, notice may be given as soon as the instrument is dishonored, and unless delay is excused as hereinafter provided, must be given within the times fixed by this Act. The law as to parties residing in the same place is as follows. Where the person giving and the person to receive notice reside in the same place, notice must be given within the following times. 1. If given at the place of business of the person to receive notice, it must be given before the close of business hours on the day following. 2. If given at his residence, it must be given before the usual hours of rest on the day following. 3. If sent by mail, it must be deposited in the post office in time to reach him in usual course on the day following. And where the parties reside in different places, the law is, where the person giving and the person to receive notice reside in different places, the notice must be given within the following times. 1. If sent by mail, it must be deposited in the post office in time to go by mail the day following the day of dishonor, or if there be no mail at a convenient hour on that day, by the next mail thereafter. 2. If given otherwise than through the post office, then within the time that notice would have been received in due course of mail, if it had been deposited in the post office within the time specified in the last subdivision. As to time of giving notice to a subsequent party, the law is, where a party receives notice of dishonor, he has, after the receipt of such notice, the same time for giving notice to antecedent parties that the holder has after the dishonor. Section 170. Notice of dishonor. Place of sending. The Negotiable Instruments Law sets out the law as to the place of sending the notice of dishonor. It states, where a party has added an address to his signature, notice of dishonor must be sent to that address, but if he has not given such address, then the notice must be sent as follows. 1. Either to the post office nearest to his place of residence, or to the post office where he is accustomed to receive his letters, or, 2, if he live in one place, and have his place of business in another, notice may be sent to either place, or, 3, if he is sojourning in another place, notice may be sent to the place where he is sojourning. But where the notice is actually received by the party within the time specified in this Act, it will be sufficient, though not sent in accordance with the requirements of this section. This is also the law generally. Section 171. Notice of dishonor. Through post office. As to sending notice through the post office, the Negotiable Instruments Law states, Where notice of dishonor is duly addressed and deposited in the post office, the sender is deemed to have given notice, notwithstanding any miscarriage in the mail. Notice is deemed to have been deposited in the post office when deposited in any branch post office or any letter box under the control of the post office department. That is, if a notice be given by the holder to an endorser by mail, addressed to the endorser at the post office nearest his residence and deposited in the post office at the proper time, the endorser will be charged whether he received the notice or not. The letter containing the notice must be posted early enough to be sent by mail on the day succeeding the dishonor of the instrument. Section 172. Notice of dishonor, when unnecessary. Notice of dishonor is dispensed with, 1. When the drawer or endorser sought to be charged is, as between the parties to the bill, the principal debtor, and has no reason to expect that it will be honored on presentment. 2. As regards the drawer, when drawer and drawee are the same person, or identical in interest. 3. When the drawer or endorser sought to be charged is the person to whom the bill is presented for payment. 4. When the drawee is fictitious and the drawer or endorser sought to be charged was aware of the fact at the time he drew or endorsed the bill. 5. When the drawer or endorser sought to be charged has received an assignment of all the property of the acceptor as security against his liability. 6. When, after the exercise of reasonable diligence, no notice of dishonor can be given to or does not reach the party sought to be discharged. The negotiable instruments law has the following provisions as to when notice of dishonor is unnecessary, and they represent the law generally. Notice of dishonor is not required to be given to an endorser in either of the following cases. 1. Where the drawee is a fictitious person or a person not having capacity to contract, and the endorser was aware of the fact at the time he endorsed the instrument. 2. Where the endorser is the person to whom the instrument is presented for payment. 3. Where the instrument was made or accepted for his accommodation. Notice of dishonor is not required to be given to the drawer in either of the following cases. 1. Where the drawer and drawee are the same person. 2. Where the drawee is a fictitious person or a person not having capacity to contract. 3. Where the drawer is the person to whom the instrument is presented for payment. 4. Where the drawer has no right to expect or require that the drawee or acceptor will honor the instrument. 5. Where the drawer has countermanded payment. Notice of dishonor may be waived, either before the time of giving notice has arrived or after the omission to give due notice, and the waiver may be express or implied. Notice of dishonor is dispensed with when, after the exercise of reasonable diligence, it cannot be given to or does not reach the parties sought to be charged. Section 173. Notice of dishonor. Excuse for failure to give notice. Certain excuses for failure to give notice of dishonor are permitted. Thus, delay in giving notice of dishonor is excused when the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct or negligence. When the cause of delay ceases to operate, notice must be given with reasonable diligence. When political disturbances interrupt and obstruct the ordinary negotiations of trade, they constitute a sufficient excuse for want of presentment or notice, upon the same principle that controls in cases of military operations or interdictions of commerce. So the prevalence of a malignant, contagious, or infectious disease, such as the cholera, yellow fever, the plague, or smallpox, which has become so extensive as to suspend all commercial business and intercourse, or to render it very hazardous to enter into the infected district, is recognized by the text writers as a sufficient excuse for not doing any act which would require an entry into such district. Where presentment or notice of dishonor has been waived by express agreement or is implied in the acts of the parties, it is unnecessary. When sudden illness or death of, or accident to, the holder or his agent prevents the presentment of the bill or note in due season, or the communication of notice, the delay is excused, provided presentment is made and notice given as promptly afterward as the circumstances reasonably permit. This doctrine rests upon the same principle as that which excuses want of punctuality when overwhelming calamities or accidents of a general nature prevent. The sudden illness or death of his agent is on the same footing as when these happen to the holder himself. If the excuse be illness, it must be of such a character as to prevent due presentment and notice by the exercise of due diligence, where the person against whom the bill is sought to be enforced has been fully secured against loss by the person principally liable on the instrument, and has promised to see to the acceptance or payment of the paper. Its presentment is unnecessary. Section 174. Notice of dishonor. Effect of notice as to prior and subsequent parties. Where notice is given by or on behalf of the holder, it inures for the benefit of all subsequent holders and all prior parties who have a right of recourse against the party to whom it is given. Where notice is given by or on behalf of a party entitled to give notice, it inures for the benefit of the holder and all parties subsequent to the party to whom notice is given. That is, notice of dishonor given by or on behalf of the holder inures to the benefit of all subsequent holders, and all prior endorsers liable on the bill who have a right of recourse against the party to whom notice is given. And notice of dishonor given by or on behalf of an endorser entitled to give notice, inures to the benefit of the holder and all endorsers liable on the bill who have a right of recourse against the party given notice. A party who receives due notice of the dishonor of a bill, as an endorser, after the receipt of such notice, has the same time in which to give notice to antecedent parties whom he desires to hold liable, as the original holder has after the dishonor of the bill. Where due notice of dishonor by non-acceptance has been given, notice of a subsequent dishonor by non-payment is not necessary unless in the meantime the instrument has been accepted. An omission to give notice of dishonor by non-acceptance does not prejudice the rights of a holder in due course subsequent to the omission. Section 175. Protest. Method of protest in its popular signification includes all the steps taken to fix the liability of a drawer or endorsers, but its accurate technical meaning is that it is the testimony of some proper person, usually a notary, that the regular legal steps to fix that liability have been taken by the holder. Its method is for the notary himself to properly present the instrument, and demand its acceptance or payment. If these are refused, to make a minute thereof on the instrument, or in his official record, the minute consisting of his initials, the year, month, and day of dishonor, and his charges. This is done on the day of the dishonor, and on the same day, or afterwards, the notary extends the protest thus noted by embodying in a certificate the facts of the protest, and his acts in making presentment, demand, and in giving notice of dishonor. To this he generally appends his official seal. Where a notary cannot be obtained, protest may be made by any respectable person. As to protest, the Negotiable Instruments Law provides as follows. The protest must be annexed to the bill or must contain a copy thereof and must be under the hand and seal of the notary making it, and must specify, 1. The time and place of presentment, 2. The fact that presentment was made and the manner thereof, 3. The cause or reason for protesting the bill, 4. The demand made and the answer given, if any, or the fact that the drawee or acceptor could not be found. Protest may be made by, 1. A notary public, or, 2. By any respectable resident of the place where the bill is dishonored, in the presence of 2 or more credible witnesses. When a bill is protested, such protest must be made on the day of its dishonor unless delay is excused as herein provided. When a bill has been duly noted, the protest may be subsequently extended as of the date of the noting. A bill must be protested at the place where it is dishonored except that when a bill drawn payable at the place of business or residence of some person other than the drawee, has been dishonored, by non-acceptance, it must be protested for non-payment at the place where it is expressed to be payable, and no further presentment for payment to, or demand on, the drawee is necessary. A bill which has been protested for non-acceptance may be subsequently protested for non-payment. Below is given a form of protest. Form of protest. United States of America, State of, County of, City of, SS. By this public instrument of protest, be it known, that on this day of, in the year of our Lord 19, I, a notary public in and for the county and state aforesaid by lawful authority duly commissioned and sworn, residing in the county and state aforesaid, at the request of holder of the original, did present the original, which is hereunto annexed, to, and did demand the said, did refuse to, the same, here insert reason, if any, why payment or acceptance was refused. Whereupon I did protest, and by these presents do publicly and solemnly protest as well against the drawer and endorsers of the said, as against all others whom it doth or may concern for exchange, re-exchange and all costs, charges, damages and interest heretofore incurred or to be hereafter incurred for want of the same, and I do hereby certify that on their day of 1900 I did give due and written notice, signed by me, of the presentment and protest of the foregoing, to the respective endorsers of the said instrument, and informing that held liable for the payment of said, and on the same day, in the evening, I deposited the same in the post office contained in a securely sealed post-paid wrapper, duly directed and subscribed to said as follows, to wit, 2. The above-named places and addresses being the reputed place of residence and address of the persons to whom such notice was so addressed and the post office nearest thereto. Thus done and protested in the city of, in the county and state aforesaid, in the presence of, and witnesses. In testimony whereof, I have hereunto set my hand and affixed my official seal this day of, 19, seal. Notary Public. My commission expires on their day of, 19, fees protest. Record notices postage total registered volume. Page. Section 176. Protest. Purpose. The dishonor must be brought to the attention of the person secondarily liable on the instrument. That is, to the endorsers or drawer. For subject to the provisions of this Act, when the instrument is dishonored by non-payment an immediate right of recourse to all parties secondarily liable thereon accrues to the holder. The notice may be made by a notary public. The instrument is presented for payment and payment is refused, then the instrument may be taken by a notary public to the party and the party may state that he refuses to pay it. The notary makes a statement to that effect and attaches his seal, that it has been dishonored, and that he has protested it for non-payment. The notary keeps this or he may send his sworn statement, one copy to one person and one to the other. This is the protest, it is not the notice of protest. The protest is a solemn declaration made by the notary public that the paper has been dishonored. Now, when suit is brought on the paper, it is absolutely necessary that proof be shown. So when you come to prove your case as the holder of an instrument you must prove that there has been a protest of the instrument, that it has been presented for payment or acceptance to the person liable and that it has been refused. That is part of your case. And when you come to the trial, this statement of the protest by the notary is a part of your case. It is the same as a deposition. It can go into evidence anywhere and will prove the case just the same as a deposition. For this certificate is generally accepted as evidence of the facts set forth in its terms, and its production obviates the necessity of proof of these facts by witnesses in open court. The main purpose of the protest, therefore, is to furnish to the holder legal testimony of presentment, demand, and notice of dishonor, to be used in actions against the drawer and endorsers. And the notary's certificate of protest is only evidence of those facts which are stated therein and which it is the duty of the notary to note in making presentment and demand for payment. Collateral facts noted by the certificate must be proved by other evidence. A protest certificate is only prima facie evidence and all facts stated therein may be disproved by competent evidence showing the statements to be untrue. Section 177. Protest. Notice of. After the notary protests the instrument he sends notice to all the parties on the instrument. He can do this in several ways. He might send it to the person who sent the paper in for collection. Then the notary public would send his notice of protest for the other parties on the instrument, to the last person on the instrument, and he would say, "Notice is enclosed herewith to be sent to the other parties." If the holder has sent notice to all the parties, he is entitled to come in and recover because he has performed his contract. He has sent notice to all the parties on the instrument that he intends to recover against them. Now, if the endorsee is D and he has sent notice to all the other endorsers, he can proceed against all or any one of them. C gets the notices and he sends out the notices to those who preceded him and that holds them, but they will be held already by the notices sent them by the other man. It is just performing the contract which was entered into in the way a merchant would do it. It is performing the contract which was entered into originally so that you may come within the terms of the contract. Below is given a form of notice. Form of notice of protest, state of, county of, SS. 19:2. You will please take notice that a $4 dated, payable, after, drawn by, in favor of, on, accepted by, endorsed by, you and due, has been protested by me on this day for none. After having made legal demand for the same, I hereby, at the request of the holder thereof, notify you that the said holder looks to you for payment, damages, interest and costs as endorser thereof. Very respectfully, Notary Public. My commission expires on their day of. 19. Section 178. Protest. What should be protested and what not necessary. As to what should be protested and what is unnecessary to protest, the Negotiable Instruments Law has the following provisions. Where any negotiable instrument has been dishonored, it may be protested for non-acceptance or non-payment, as the case may be, but protest is not required except in the case of foreign bills of exchange. Where a foreign bill appearing on its face to be such is dishonored by non-acceptance, it must be duly protested for non-acceptance, and where such a bill which has not previously been dishonored by non-acceptance is dishonored by non-payment, it must be duly protested for non-payment. If it is not so protested, the drawer and endorsers are discharged. Where a bill does not appear on its face to be a foreign bill, protest thereof in case of dishonor is unnecessary. A foreign bill must be presented by a notary public, because, from the needs of the case, some act of a universally recognized authority is called for by force of custom. The official act of the notary public is of recognized authority throughout the world. Protest by notaries public of a foreign note is unnecessary, unless it is endorsed, but, if endorsed, its protest by a notary public, according to the weight of authority, is required, because the endorsement of a note is essentially a bill drawn on the maker. The convenience of proving the essential facts of dishonor by notarial certificate has caused the enactment in some of the states of statutes requiring or permitting the protesting of inland bills and notes. Section 179. Protest. Waiver. Protest is waived by express or implied waiver of a presentment for payment, and protest is dispensed with by the same circumstances which would dispense with notice of dishonor in the case of an inland bill, and circumstances excusing delay in giving notice of dishonor will excuse delay in protesting. The Negotiable Instruments Law provides, protest is dispensed with by any circumstances which would dispense with notice of dishonor. Delay in noting or protesting is excused when delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence. When the cause of delay ceases to operate, the bill must be noted or protested with reasonable diligence. Where the waiver is embodied in the instrument itself, it is binding upon all parties, but where it is written above the signature of an endorser, it binds him only. A waiver or protest, whether in the case of a foreign bill of exchange or other negotiable instrument, is deemed to be a waiver not only of a formal protest, but also of presentment and notice of dishonor. Section 180. Protest. Miscellaneous matters. A bill dishonored for non-acceptance must be protested, but when this is done it need not be subsequently protested for non-payment. Any holder may present the bill or note for payment and receive payment, but in case payment is refused and protest becomes necessary, the notary public who makes the protest is obliged, by law, to make a second demand, so that he can of his own personal knowledge certify to the fact of dishonor. A bill must be protested at the place where it is dishonored, but if the domicile and place of payment are different it may be protested at either place. When the laws are in conflict, the validity of the protest will be determined by the law of the place where it is made. The notary's minutes made on the bill or note, such as his initials, the date and the like, are made for his convenience, since he by the law merchant is required to make the protest the same day that the presentment and demand were made, and this short form is equivalent to the protest itself, and the more formal protest may be made out later from the minutes. When the acceptor of a bill becomes bankrupt or makes an assignment before its maturity, it may be protested for better security. Where the acceptor has been adjudged a bankrupt or an insolvent, or has made an assignment for the benefit of creditors, before the bill matures, The holder may cause the bill to be protested for better security against the drawer and endorsers. Where a bill is lost or destroyed or is wrongly detained from the person entitled to hold it, protest may be made on a copy or written particulars thereof. The notary public must present the paper, if you desire to protest it, either for non-payment or non-acceptance. The custom in some cities is to make 2 presentments, twice in the same day. If it is not accepted when it is presented in the forenoon, it is taken back again in the afternoon and is protested.